The second week of testimony in the trial over the death of George Floyd was powerful. The Hennepin County Chief Medical Examiner saying the restraint was more than Floyd's heart could take as former Minneapolis police officer Derek Chauvin pressed his knee on Floyd's neck last year. The prosecution shifting focus to the specific cause of Floyd's death as the defense argues that Floyd died of a drug overdose and pre-existing health conditions.
Those other contributing conditions are not conditions that you consider direct causes. Is that true?
They are not direct causes of Mr. Floyd's death, that's true. They're contributing causes.
And in terms of manner of death, you found then, and do you stand by today, that the manner of death for Mr. Floyd was, as you would call it, homicide?
Yes, I would still classify it as a homicide today.
Ben Crump, the attorney representing George Floyd's family, joined me in the last hour saying that Derek Chauvin's actions are all that matters.
We just have to remain focused on what we saw in that video of Derek Chauvin putting his knee on George Floyd's neck for 9 minutes and 29 seconds. The only thing that killed George Perry Floyd Jr. was an overdose of excessive force.
All right, back with me now, Shan, a defense attorney and a former federal prosecutor, and Michael Zeldin, a former federal prosecutor and Justice Department official. All right, glad you're back with me. So, Michael, can it get any more damning for the defendant from the medical examiner to renowned pulmonologist? George Floyd died of homicide because of the officer's knee to the neck. That was their testimony. How will and can the defense dispute this? Change the minds, perhaps influence the jurors?
Well, I think what the defense really is stuck with at this point is trying to get the lesser charge of manslaughter. That is culpable negligence, creating an unreasonable risk of injury to Floyd. What the prosecutor is really going for is the murder charges, which is purposefully engaging in activity that would likely cause the result either through a deprived mind or a other, sort of felonious act while committing an assault. So I think you've got a battle here because I don't think you can really defend Chauvin's actions on the merits as much as you have to, at this point, in my mind, go for the lesser included offense of manslaughter.
And Shan, the defense is also going to try to paint a different picture of the victim, George Floyd, trying to blame drug use for his death. Listen to this testimony from one of the expert witnesses.
It was not the type of death that has been reported in fentanyl overdose, for example, where someone becomes very sleepy and then just sort of gradually, calmly, peacefully stops breathing. This was not that kind of a death. The activities of the law enforcement officers resulted in Mr. Floyd's death, and that specifically those activities were the subdual, the restraint, and the neck compression.
So we heard from the family attorney, Ben Crump, earlier, who said, Shan, that they are expecting the defense will try to take the direction of George Floyd's death comes because of pre-existing conditions, comes because of his, life and habits, but not because of what that officer did.
I think that is what the defense is trying to do. I think right now they're going to have a very uphill battle trying to take on the medical testimony directly. They have to be a little bit nuanced about it, and to Michael's point, what they have to do is try to move this into recklessness, negligence, into that arena. And there's room for that, even in Dr. Baker's testimony, where he clarifies that it's really the police actions that was too much for Mr. Floyd. Well, it's too much in the context of his underlying conditions. So they can focus on that and try to make the point that Chauvin didn't know about those underlying conditions. He's stressed from the crowd, and he can't be held accountable for the death that happened. But let's remember, the proposed jury instructions are not going to require the prosecution prove that Chauvin's actions were the only cause of death. It's probably going to be a substantial contribution to it. They've already made that, so I think they really just have to try to tamp it down as much as possible to make light of the fact, to bring into the light that Chauvin couldn't have known about these underlying conditions and try and go in that direction.
And so, Michael, will the defense, try to establish that perhaps Chauvin didn't even know that the method he was using was lethal? And if you try to make that argument, how do you do that without putting Derek Chauvin on the stand himself? Doesn't he also have to express or explain the fear that his attorneys say that he felt as a result of a crowd forming?
Yeah, it's a defense attorney's nightmare. Chauvin, in some sense, has to take the stand to articulate that, state of mind, and that he wasn't, intending to kill George Floyd, but that the circumstances that surrounded him caused him to behave in this way, and this way was reasonable. But in some sense, it's the last person you want on the stand if you're the defense attorney, because he's so vulnerable to the withering attack of 9 minutes plus on a person's neck, several minutes of which incurred when the person was essentially unconscious. And remember, in this case, the prosecutor doesn't need to prove that Chauvin intended to kill Floyd. He has to only prove that his actions resulted in Floyd's death and that those actions were unreasonable or were the result of a deprived mind. And I think that they've done that so far.
And Shan, all those descriptions, people can't forget that George Floyd was handcuffed. And so you have to wonder whether the defense now is at all worried about its case and is considering some sort of plea. I mean, it just seems to get worse by the moment based on the prosecution witnesses, which have been, very strong and very damning. Do you believe that they are seriously considering right now whether a plea is something they need to be discussing seriously?
If I were them, I would be considering that, but I'm not really seeing any signs of a crack in his defense counsel's view on this. He's just kind of like plodding forward, doing the same thing that he was doing before. He's going to have to really up his game some here if he's going to exploit some of the possible nuances in Dr. Baker's testimony. I don't know that he's going to be able to do that.
Eric Nelson, the defense attorney, you mean?
Yes, yes. And I think for the prosecution to offer a plea mid-trial, they're going to extract a heavy price for that. I mean, when I was a prosecutor, I'm not going to offer you a good deal now that I'm already in trial and I'm doing well. So they're not going to give him some third-degree manslaughter type charge if they're going to plead him out in the middle of the trial. So I think that's unlikely to happen.
All right. Shan Wu, Michael Zeldin, good to see both of you. Thank you so much.
Good to see you, Fred.
All right, still to come. Firefighters going beyond the call of duty to fight coronavirus.